timely given advance notice of their intent to rescind.
Understood. It seems to me that the big question in this case is whether your client should have been required to elect remedies at all.
Absolutely, absolutely. And
did you ever tell the trial court that he shouldn't have been required to elect remedies?
Your Honor, if you look at the case law, the situation at the time of the election, there's cases that in Arizona, there was Arizona appellate court cases, and I don't remember the exact which one it was, that held that you had to elect by the conclusion of trial prior to sending the case to the jury. So there was some authority out there for that proposition. So I don't know how successful I would have been if we had raised that. But secondly,
well, let me just make sure. So you didn't raise an objection to the notion that you must elect remedies?
We did not. However, you also have to understand at the time we made that election, we had substantial comfort in the belief that rescission was an available remedy. Not only the factual record, there was the October 30, 2006 letter from David Carruthers to Clinton Underhill in which, he, within 2 months after the transaction, he's saying, look, I believe that you defrauded me. I think this transaction is void. I demand that you return our stock certificates to us until we can work out a fair price for the transaction.
You're getting more to the correctness of the court's decision. Do you contend now that election of remedies applies in this case, or
no? We don't. And that's the other issue, is we don't think that an election of remedies applies because if you look at the case law, in order to have a valid election of remedies, first of all, you have to have two existing available remedies to elect from that are inconsistent.
But before you get into the substance of election of remedies, where in the record did you make this argument for the first time?
Well, we didn't make it for the first time until after the court had ruled a year following the verdict that he was taking away the advisory verdict. Until that time, we were under the assumption we had won the case.
So you made it in response to the court's post-trial change of course.
Correct.
Okay.
Let me ask you a question on this point. Even if you did not think, or you don't think now, that the election issue was even, an election was even required, when you were in the midst of battle and getting ready for trial and then in trial, your client wanted rescission, correct?
That's
so
correct.
Regardless of whether you were forced to make an election or went passively into an election, Mr. Carruthers wanted rescission. Is that correct?
That's correct, although I will go so far as to say we had two alternative bases. One is the common law notion of rescission of a contract with all the common law defenses that were applied by the court. The second was we had a statutory securities fraud claim, which under ARS 44-2, I'm not going to belabor it then. Obviously, our position is that was not even an equitable rescission claim. That was a statutory claim for a statutory remedy where we had the absolute statutory right upon a determination that there had been misrepresentations in the transaction to declare the transaction void.
Well, the transaction under the statute, I believe, is voidable, and the question has arisen in the briefing whether equitable defenses apply to statutory rescission. I think it's not enough just to say that the rescission is statutory. There are statutes that give you a right to an injunction. That doesn't make the injunction not an equitable remedy.
But there are a number of cases, and we cite them. If you look at our reply brief, we had tables of statutes where there was an express incorporation of either rescission specifically or more generically common law remedies. That's not what you have here. This statute doesn't incorporate common law. In fact, I think that's one of the big reasons that the trial court erred, is he tried to draw an analogy to federal court decisions interpreting private rights of action under Section 10b-5. And the problem with that comparison is Section 10b-5 has no express statutory remedy, and instead it implies a common law cause of action, private right of action. And when you imply that common law right of action, you're incorporating all of the common law, including the equitable aspects of common law. In this case, there was no incorporation. This was, in our position, an express statutory scheme for broad remedial protection of people like the appellants who are defrauded in a transaction, and it had its own remedy provided. And it was not simply an incorporation of common law remedies, either expressly or impliedly.
Well, could any equitable defense apply? Let's say unclean hands.
I would say no, because again,
Well,
if you have the Valley Drive-In case is a perfect example of a situation where the courts have held that if you have a comprehensive statutory scheme that provides its own remedies, that the courts are not empowered to craft onto it equitable considerations.
That taken to its limit could be a rather extreme statement. I'm not saying this about your client at all, but assume for a moment you have two parties who are trying to defraud one another. One succeeds in defrauding the other and then loses the case. Does the unclean motivation of the purported victim not count at all in the statutory claim?
And I don't know how that hypothetical would apply to this case, because in this instance, the remedy that the statute provides is that if there is fraud in connection with the transaction, you can simply declare it void and it's no transaction at all. So why should a party who admittedly committed fraud themselves in order to make the transaction happen complain that the other side had dishonest motives as well, and therefore you should what? Ignore the right to void the transaction and enforce the transaction as perpetrated?
Well, that's what typically happens in rescission, and if you're going to say that this act changed that doctrine, I would have expected to see some language in the act that does so.
Well, except that, again, if you have to ask yourself, if all the legislature was doing was simply incorporating or reiterating available remedies under the common law, why would they have bothered to enact a specific statutory remedy at all? Because if all you're doing is parroting what already exists, you should either do nothing in terms of a remedy, or you should do as other Arizona statutes have done and expressly incorporate common law remedies. But when you create your own statutory remedy, basically the courts, I think, have to believe that that fills the field with regard to what rights you have if you pursue that specific claim. That's not to say that the same plaintiffs couldn't pursue parallel, as was done in this case, common law claims. In other words, there's nothing that says you can't simultaneously pursue both a statutory remedy under the Securities Act and a common law remedy under common law fraud allegations. So again, all I'm dealing with in this portion of my argument is the specifics of you have a statutory scheme that is supposedly remedial, broadly construed, provides its own remedy, and the court, instead of applying that specific statutory remedy, decides to craft onto it equitable considerations of contractual rescission. And I think that is exactly the situation they were dealing with in the Valley Drive-In case, which I believe was one where a trial court concluded that a defendant who was trying to reclaim their own property under, I think, an attachment statute or something, was allowed to post like a $100 bond instead of the statutory remedy, which provides that you have to post 2 times the value of the property. And the court said you can't do that because the statute enacted by the legislature had a specific remedy provision. The court didn't have the equitable power to say, well, that's kind of a hardship because this defendant doesn't have enough money to put up the full 2 times, so I'm going to let him put up $100 instead. And so I don't know how that is really distinguishable from our situation. The other issues that I have is how is this, since it is a statutory remedy, it's not true rescission because, again, in rescission, the court has to apply its own equitable considerations to whether the fairness of the transaction dictates that it should be unwound or rescinded. In the statute, the court doesn't serve that role. Once the violations are found under the statute, fraud in connection with the purchase of the stock, then the remedy is manifest. It says the seller has a right to void the transaction. And so, again, there's no equity to apply there in terms of whether justness allows this remedy to be applicable. Because it's a statutory remedy, and because it does not incorporate equitable considerations, the securities fraud case should have been tried to a jury as a matter of right. So obviously one of our arguments is that the court erred because we specifically requested that our securities fraud claims be tried as a matter of right to a jury, and the court denied that request, finding it was an equitable claim, and therefore it was just an advisory jury as to that as well.
May I ask you to shift gears a little bit?
Sure.
Let's suppose that, that we do conclude that equitable defenses are available under the security statute. But nevertheless, we agree with you that the court should not have barred rescission. What do you see the appropriate scope of a remand order?
Well, we've asked for, and I'll be honest with you, we have, at this point, changed circumstances years down the road from when that verdict occurred. We have a hierarchy. Our number one request would be that the court remand this case for a new trial on the issue of damages on the grounds that there was no double recovery potential here, that there was no policy, that if the court had found, as it obviously did, that the absolute unambiguous tender that took place in December of 2008 wasn't sufficient or wasn't timely enough to allow for the remedy of rescission to exist. That was a fact that existed prior to trial. That was a fact that existed when the court rejected a futility argument and allowed us to amend to seek rescission in our complaint. That was a fact that existed when the court denied a summary judgment motion based on that issue. And that was a fact that existed when the court denied a Rule 50 motion for judgment as a matter of law at the conclusion of trial, finding expressly and in writing that the Clinton Underhill had neither alleged nor proven any prejudice by the delay, and that, in fact, the October 30 letter represented a good faith, timely effort to put them on notice that we intended to void or unwind the transaction. So, given that history, if none of that was sufficient in the eyes of the court, then allowing this case to go to the jury, certainly we did not have full knowledge of facts that would suggest that rescission was not an available remedy at the conclusion of trial. Now, if in fact it was an unavailable remedy, then I think that we've cited a substantial case law that says that at that point we should have been allowed to proceed and go forward with our claim on damages. And we specifically requested in our motion for a new trial on damages only, given the fact that liability had already been found by the jury, and all we were saying was, look, you concluded now that for whatever reason we're not entitled to the remedy of rescission. It's not available to us. In that case, we didn't have that choice of two available remedies, because all of the facts in which you're relying, because again it was the judge who made that decision, he knew all those facts before the case went to the jury, and so that means it was not available to us when we were forced to make our election, because at least in his mind it wasn't there. And so I would like to reserve a few minutes, if I may, for rebuttal.
Very well.
May it please the court, my name is John Egbert. I represent the Underhills, the Appleys in this matter. I'd like to start off where we started off with the questioning of opposing counsel with, because I think it's important to step back and make sure we understand what the issues really were in not only in the trial court, but the issues that were raised in the opening brief, because there was no question. There was no debate about whether this was an election of remedies case. There was no demand by the trial court judge that on a certain date they had to elect, nor was there any type of a objection made by the plaintiffs in the trial court that, hey, we don't have to elect here at all.
No, there wasn't a strong push against the notion of election, but the actual election seems to have been hard fought throughout this case. from the opposition to the amendment of the complaint all the way up to the post-trial proceedings. And I think in footnote 4 of your brief, you refer to the moment when the court said, okay, what are you going to do?
Yes, the court said, have you elected yet? And that's the only reference to the give and take in the record that was cited to
But I'm a
this
little
court.
reluctant to allow the parties in the court simply to agree on law that doesn't exist. I'm not sure that that you've got a solid legal foundation for saying this is an election of remedies cases. And if the law doesn't support it, I'm become a little less interested in what the parties thought it might support.
But Your Honor, there is a concept not of raising timely objections in the trial court. And,
It really
and
is,
cases,
but I'm asking you to address the actual merits of the legal issue. I'm familiar with the concept of waiver.
Okay. And I also, just before I leave the concept of waiver, I want to point out that if you review the issues raised in the opening brief, this is not one of them. And so, I think cases are litigated all the time based on the incorrect
But surely
notions.
you've got a better argument than they forgot.
I do have a great argument with respect to election of remedies, I believe, and that is simply that the case law in Arizona is such that when a party has a choice between saying, I'm going to affirm the contract and sue for damages, or I'm going to say the contract is no good, I don't want the contract anymore, I want rescission, that you can't do both. In fact, that's what the Arizona Supreme Court said many years ago when it says that
Well, that's okay. I grant you the Jennings versus Lee and the
Yes.
other cases that have said that. And I think Judge Swan has made this, raised this as a question. All of the claims here were fraud or fraud-based claims or misrepresentation. I think there's a breach of fiduciary duty, but they're all basically kind of sounding in fraud. From the get-go, I struggled with this because I'm thinking, I don't see an election of remedy situation. This Mr. Crothers was not attempting to argue alternative or inconsistent theories. It seemed to me that from the get-go, in some form or fashion, he wanted a portion of his stock back. So whether he called it initially restitution or rescission in part or whatever it was, he was wanting some of the stock back, maybe all of it back, depending on the value. So he was always asking for basically the deal to be unwound.
No, Your Honor, and that's the important point here. September 2006 is when he learns of the alleged fraud.
Right.
October 2006 is where he sends the letter. And the letter simply says, look, I want more money under the agreement. And until we can arrive at a deal of how much more money, I want to be able to vote that stock. I want you to return it to me until that time. So he's not saying, I want to unwind this deal. I'm going to give you back your money and you give me back my stock. He doesn't say that. And to quote the language.
I've got the letter right here.
Right.
Okay.
He says, initially I would like to attempt to remedy the situation privately outside the legal system. In my view, this could be accomplished by simply calculating the additional money owed. What does it mean to be owed? Owed under the agreement. So he's affirming the agreement.
Well, did the agreement contain some formula for overpayment in case of fraud?
No, but it contained-
That's not owed under the agreement. That's owed as damages for fraud in the inducement, isn't it?
No, Your Honor. There is a formula. It's X dollars per share. In this case, the agreement was $6,000 per share, and he said that's not enough. It should have been something north of $6,000 per share. And so he's saying we need to come up with find out what the stock was really worth, put that into the 6,000 times blank, and then that's how much more you have to pay me.
Well, let me cast this in a different light. You cited in your brief Landon versus Ford, right? So you're familiar with that case.
Yes.
And that case specifically says that then when there's just one theory, and it's a fraud theory, a plaintiff can seek rescission, damages, or both, because there is no inconsistency between the remedies when one doesn't have to disclaim and seek the benefit of the contract. So, if that's what the Supreme Court has said, why is this an election of remedies case? I don't see the plaintiff here looking for the benefit of the bargain on the one hand and denying that there was ever a contract on the other hand. I see the plaintiff basically articulating a unified theory. I sold you my stuff. You didn't tell me what it was worth. I either want my stuff back or I want the money to make me whole. But it doesn't seem that there's any internal inconsistency there.
But Your Honor, you can't say I want my stuff back and have it be just that. I want my stuff back means I don't want the deal anymore. I don't want the contract at all. I want to rescind it.
I want my stuff back. Right. I want to rescind the contract and or get damages. And if damages are necessary to make me whole after all that has happened, I can get both. That's what Landon v. Ford says.
But there's a concept of damages to make one whole in the context of rescission. There are rescissionary damages.
Right.
But that's not what we're talking about here is not that. We're talking about I either want to just get rid of the contract and just start over. Let's go back to where we were.
Right.
I get my stock, you get your money.
That's what he asked for at trial.
That's what he ultimately asked for when he finally amended his complaint at the end. But when the other option that he wanted and that he said in his October letter and later when he initially filed his complaint was that I want to keep the contract. I want the deal. I want you to keep the stock. All I want is more money for my stock. That is inconsistent.
That more money, that's a big deal point. I mean, essentially he's saying, I want to renegotiate the deal. You're going to give me a lot more money, but I want my stuff back, or my stock back, rather.
But no, Your Honor, that's a damage calculation. I sold you something that was worth $10,000, just to pick a number, and you only gave me $6,000 for it. So my damage is the delta. I want the agreement. I want the deal to be left in place. That is absolutely inconsistent. But I think there's one thing that we need, before I run out of all my time, I want to make sure that we understand that there was a waiver of the damage claim by Judge Gould saying to the parties, okay, our side says we'd like to move to dismiss the damage claim. Now that they've said they want rescission, we want to get rid of the alternative claim, and there was no objection.
There's a little more context to it than that, though. I mean, that motion came after the trial judge said you have neither pled nor proved prejudice necessary to disallow rescission. You've got a pretty firm ruling saying rescission is an available remedy. You then move to dismiss the damages. Then rescission goes away, making the election illusory, and the damages are never reinstated. Doesn't that seem
Unusual.
Well, Your Honor, if there's an argument, if we really are going to say, okay, they really were kind of a unified theory, then the unified theory was existing at that point in time. They should have said, no, Your Honor, we've got a unified theory. We should be able to do both. We're not, this isn't inconsistent. It's wrong to dismiss my damages claim. I'm objecting. If we're going to give them all that benefit of the doubt, then
but
we should.
Wouldn't it be the right thing if they had basically been led to believe that they had a rescission claim? Wouldn't it be the right thing not to demand double recovery? I mean, they couldn't, in good conscience, demand double recovery. So here they go. They've got their rescission. That's what they want. They're going forward with it. It would be somewhat disingenuous to say, oh yeah, and we want damages in addition.
But under that theory, we're kind of doing it both ways. There's all time. For example, people go to jury trials and get a verdict on breach of contract and breach of an alternative quasi-contract remedy. They can't get both. They can't get, if they get $20,000 damages under one, they can't also get $20,000 damages under the other. And so if we're going to say this is a unified theory from the beginning, and then at that point in time say, yeah, but it's not fair because it would be in double recovery. No, it's not double recovery. It's a unified theory.
Okay. Under what view of the law? I mean, give me the best case to say that our law envisions having somebody prove their case on the merits, but then be required to make a high-stakes choice about whether their remedy will be illusory. I'm not aware of that principle in American law.
Well, this first of all, this was an issue that they were very aware of. It wasn't like it came as a surprise. I mean, from the very beginning.
Whether it was I'm sure it was a surprise when they got the post-trial ruling. I bet if we asked, was it a surprise, they would probably say yes. But surprise aside, how can we as the courts actually sanction saying you've proved your case, congratulations. Now let's flip a coin and see if you get a remedy.
But it's not a flip of the coin, Your Honor. There was 27 months of delay in making a request for rescission. And what we're doing now is...
Well, I want to get there with you, but let's assume for a moment that the decision that rescission should have been unavailable was right. Okay? Let's assume that for the sake of argument. I'm asking structurally, why is it that at the end of trial, a plaintiff is put to the position of choosing a remedy that might be illusory or nothing at all? Why isn't it the better rule that if rescission is unavailable, the damage claim is simply reinstated and evaluated?
Because, I mean, that goes contrary to the fundamental notions of things like finality. I mean, it happens all the time, for example.
Well, the case was final when the jury ruled. I mean, the finality has been a little bit of an amorphous concept.
No, the jury was advisory. If we accept that concept that the jury was advisory, there was no finality with that. And so it happens all the time where people elect to litigate 3 causes of action. And if we were to say, okay, well, gee, it turns out that none of those 3 ultimately were available to them, they were all illusory, then why not allow them to now bring a new lawsuit? Or get a new trial to bring up a 4th one that they chose never to raise in the first place.
Well, if you want to cast this in terms of claims and remedies, isn't it sort of like saying you have a contract case and a tort case? We're almost the way through trial. Now, pick your favorite claim, and we'll see if you win. Even though you may have proven them both, you have to pick your favorite one, and if that favorite one is unavailable, then you get nothing. That's the structure that I'm seeing that I'm unfamiliar with.
Well, and Your Honor, I guess in some ways I'm a bit at a disadvantage because this was not the issue that was raised or that I briefed or that I was prepared to argue today in terms of whether this whole underlying concept of having to make an election from the very beginning was defective and therefore we need to start all over.
Well, can I jump in here? Let's assume they're stuck with their election of rescission. What about the notion that the trial court erred in applying the prejudice factor in weighing the availability of rescission? It seems to me that the uncertainty or the, quote, cloud was the allegation of fraud. And if the court erred in finding prejudice as a matter of law, where does that leave us?
Well, I think there's 2 responses to that, Your Honor. One is that the rule under rescission is that the court looks at the totality of the circumstances, and fraud is admittedly one of the. Prejudice is admittedly one of those factors, but it's not dispositive.
No.
It's not absolutely required.
Court found prejudice, and let's say we think it was wrong as a matter of law. Can we then reweigh and say, well, it would have found this anyway? I don't think we can do that.
No, but I think it is a finding, and therefore it's subject to the clearly erroneous standard that so unless you can say that there's no way the judge, even without that piece, that factor going in that direction, there's no way the judge could have found still that there was unreasonable delay, then only on that circumstances would you then reverse. Otherwise, if it's possible, if it's reasonable for the judge, even leaving out that factor, could still determine that it was unreasonable under the circumstances. For example, the 27 months worth of waiting around.
Well, let's talk about the 27 months. October 2006, your client receives a letter accusing, for Mr. Carruthers, basically accusing him of fraud.
Correct.
And during this 27 months, as he's trying to manage the company, he is now facing accusations of fraud. That by itself would have been the prejudice. So how is the fact that there was a 27-month delay in asking for rescission any more prejudicial than the pendency of the allegations of fraud and misconduct and breach of fiduciary duty that then were incorporated into a complaint about a year or so later?
Well, here's a fair inference from that finding, and that is that this whole dispute in this closely held corporation was who's going to have control. And these shares that we're talking about shifted control one way or the other. And if somebody says, look, I'm not asking for rescission, I'm asking just for more money, then Mr. Underhill has the ability for 27 months to assume, look, one way or the other, I may have to pay more money at the end of the day, worst case scenario, if I lose this. But if I don't, whether I lose it or not, I have control of this company, and I'm going to invest my time, my energies, my efforts to take it the direction I see fit.
But the control is always subject to divestiture. And that happened as a nature of these allegations right from the beginning.
But, Your Honor, it's only subject.
He didn't come out with his checkbook and say, let me make you happy, Mr. Crothers. Let me write you a check. So there was always going to be a risk that these folks could not reach an agreement, which they evidently did not. After all, this went to trial, and thus all of the disruption to his management of the company was in existence from the beginning of the accusations of fraud right through the end of the case, all the way along.
That assumes that there was a timely demand for rescission. But if there wasn't, if all that Mr. Underhill is hearing is, I want more money, if I'm right about fraud, then you owe me more money.
Okay, right from the beginning of October 2006, Mr. Crothers saying, you can't vote that stock. I'll vote it in the interim while we're trying to resolve this. So he had already been arguably dispossessed of control.
I guess I'm wondering, during what period was Mr. Underhill able to breathe a sigh of relief and say, well, at least rescission is off the table. I have my control consolidated. It's just money now. When was that period? And how did Mr. Crothers create that?
It wasn't off the table in the sense that it was always lurking out there. In fact, it was lurking out there until the judge made his decision, but he decided that it was untimely. And the point is that for the first 27 months after he gets, the other side determines that there's been fraud, 26 months from the time he gets the letter, all he's hearing is, look, in the meantime, I want my stock back, but I'm not asking to rescind this agreement. I just want more money for my stock. I want you to pay me more. So he's able to. At
what point, can you cite a place in the record where the communication was, I'm not seeking to rescind this agreement?
No,
that's what you just said.
That's right, but
where is it in the record?
It's a characterization. It's an inference from. I can, instead of characterizing that, I can read what it says from the letter. But the letter does say that in the meantime, I want my stock back. But the meantime of what? The meantime until you pay me more money. So his claim is more money. And the judge made a determination that that was not a unambiguous demand for rescission. And that's what
Nor was it an unambiguous restoration of control to Mr. Underhill.
No.
The argument here is prejudice, that Mr. Underhill was somehow sandbagged by this demand for rescission, which seems to have been the lifeblood of this entire dispute.
No, Your Honor, that it wasn't a situation where we're talking about merely sandbagging. We're talking about that this was a situation where if they would have, in October, instead of what they did say, if they would have said, we're demanding rescission, we're willing to give you back your money, we want our stock back. If that's what they would have said, then there's all kinds of possibilities in terms of what Mr. Underhill would have done or would have not done under that circumstance, because then there really was a risk that he was not going to have control, and he could choose, gee, am I really going to invest the next 27 months of my life in all this hard effort and directing this company when it may all be for naught at the end of the day? That's the scenario. That's the reason why there was prejudice. And that's a fair inference from the findings of Judge Gould in this matter, that the 27-month delay was such that Mr. Underhill wasn't sure whether or not he was going to have control if they would have made that kind of demand. They didn't, and it didn't eliminate all concerns, granted, but it sure was a lot better than hearing on October 2006. I want rescission right now.
Okay.
I'm out of
Any
time.
further questions? All right, thank you very much. Mr. Schenk, come on up, and I recognize your colleague went a little bit over time. Will be mildly flexible.
First of all, let me tell you, while my my opposing counsel talks about all of these implications that Clinton Underhill was prejudiced because he was uncertain in his mind whether he had control, he's not cited anywhere in the record where that was in evidence anywhere. That's the whole problem here. In fact, going back to Judge Gould's ruling on the Rule 50 motion, he specifically stated in his findings that Clinton Underhill had neither alleged nor offered any evidence of prejudice. And that's consistent with what the record is in this case. Clinton Underhill didn't take the stand and talk about his angst-ridden nights wondering whether he was going to have control. That's just not part of the record. It's just an inference made up out of whole cloth, first by the trial court and then later by opposing counsel. It's not part of the record before this court. Ultimately, I'd like to get back to the election of remedies because that's, in my mind, we have a number of other issues we haven't even addressed, but I just because of time constraints, I'd like to go back to the election of remedies. I think that
You might want to begin by telling us why the issue isn't waived.
I don't believe the issue is waived or waivable because we were specifically asked by the court to make an election. There is case law out there that says that there was case law at the time that said that you needed to make an election before the case went to the jury. I didn't have any reason to, at that point, believe that the court's ruling in requiring us to make an election, which he did. I mean, I realize it wasn't dictatorial. You've got 30 seconds to make the election, but it was pretty clear that, all along in stuff that may not even be on the record, we were instructed that we were going to have to make the election. And so when he said, are you made an election? We complied with the request and didn't
But
say.
constitutional claims can be waived by failure to object. I'm having a very difficult time seeing where you preserve this at all as an issue for appeal.
Well, I think we preserved it because we filed our motion for new trial, and we extensively briefed in that motion for new trial when we requested a new trial on the issue of damages why that was not an election of remedy situation. So all of that is raised in the trial court that, look.
But a timely objection is designed so that the trial court can avoid error, and you make a record at that point. A new argument raised for the first time in a motion for new trial is generally not considered on appeal.
But you have to consider the context, Your Honor. At the point in time where he did this, we had every reason to believe that rescission was an available remedy to us.
You thought he was right about election of remedies, apparently.
And I thought he was right about election of remedies at that point.
Is it that he didn't become wrong about election of remedies until the election presented an unforeseen peril, that is, that damages would likewise be unavailable?
Exactly. That we would basically, that he would end up, and I don't for a minute ascribe any ill motive on the part of the trial court, but just by the convergence of the various rulings he made, he did convert the justice system into a game of chance, as the court alluded to, where you're sitting there believing that you have to make an election, and I think it was a reasonable belief based on the existing law at the time, where the court is asking you to make the election, and you believe that you have two available remedies, and you pick the one that you prefer at that point, which in our case was rescission, having no reason to believe that rescission was not available. We've cited ample case law in our briefs for the proposition that, in fact, if there was not if there were not in existence two inconsistent available remedies, then the election of remedies doctrine doesn't even apply. Because if it's illusory, you believe you have two inconsistent remedies, but in reality you only have one, then if you pick the one that's not available, the courts say, well, you then have the right to proceed with the one that is available. In fact, if you look at the old Supreme Court case, McRae v. Lois Grunion Memorial Clinic, that was an early Arizona Supreme Court case that basically said exactly that if you start out pursuing an equitable remedy in a case and it turns out that remedy, for whatever reason, is either not available or not granted to you, you should have the right to go forward then and get your remedy at law. And so you have Supreme Court authority right on point, I believe, that says that we should have, at the point, because I don't think that the court had given any indication until a year after the trial that we weren't going to be allowed to pursue rescission as an available remedy. And when he did that, under the McRae case, I believe that he should have, at that point, allowed us to proceed forward with a new trial on just the issue of damages. Because under McRae, that's all we were asking was, let us go forward and prove up our damages. And if you say that rescission is not available, we have a lot of arguments for why he was wrong in saying rescission wasn't available, but that's the crux of it, is we shouldn't be standing here with no remedy.
But yes, and I thank you. We are over time. I'd like to thank both sides for their arguments, very, very helpful to us. And this matter is now under advisement. We will issue a written decision in due course, and we stand adjourned.